No, this is okay. We are starting. All are
हेलो
जो आपके हाथ से दे देता हूँ। प्रधान साहब नहीं आए।
मोमेंटो देना है बता रहे थे।
ये मेरे को नाम गड़बड़ हो जाएगा।
आप देख लीजिएगा। अंजुल मैम ये मैं बाहर हमारे बच्चे
नहीं है। Very good afternoon. Hello. Very good afternoon to everybody. May I request all the participants to kindly settle on their respective seats. Kindly switch off your mobile. I welcome the dignitaries on the dais of the dais for the second session of this historical international lawyers conference, which is just inaugurated by the Honorable Prime Minister in presence of Honorable Chief Justice of India, which we all have witnessed. For this second working session of the conference, today we have a chairman of the session, the person who has tried to give a modern shape to the constitutional interpretation of the law, Honorable Justice B.R. Gavai sir, Judge Supreme Court. Let us welcome by giving big hand. As a chairman of the session, we have Honorable Mr. Justice Aniruddha Bose, Judge of the Supreme Court of India. Welcome, sir. Also, the second co-chair of the session will be Honorable Mr. Justice Rajesh Bindal, Judge of the Supreme Court of India. I welcome you, sir. We have eminent speakers on this occasion. Honorable Mr. Justice Honorable Mr. Sapna Pradhan, Malla, Judge of the Supreme Court, Nepal. Welcome. Honorable Mr. Justice Sanjay Kumar Mishra, Chief Justice. Jharkhand High Court. Welcome, sir. The topic of this second working session will be access to justice and the legal aid in a developing nations. We have near about time of 75 minutes. So I will be very brief in the beginning. Only I will request Honorable Member of the Bar Council of India from Jharkhand, Shri Prashant Singh sir, to come on a dais and welcome our Honorable Chairman of the session, Honorable Justice B.R. Gavai Sahib, by presenting a memento and the bouquet. Thank you very much. May I request Honorable Mr. Vishwajit Kumar Mishra to welcome the co-chairman of the session, Honorable Mr. Justice Aniruddha Bose Sahib, by presenting a bouquet and the memento. Welcome, sir. May I request Dr. Uday Varunjikar, Vice Chairman of the Bar Council of Maharashtra and Goa, to welcome Honorable Mr. Rajesh Bindal, the another co-chairman of this session. Welcome, sir. May I request member of the Bar Council of India, Shri Prashant Singh sir, to welcome the Honorable Speaker of the session, Honorable Mrs. Sapna Pradhan Malla, Judge of the Supreme Court of Nepal, by presenting bouquet and also memento. Welcome, madam. May I request Mr. Vishwajit Kumar Mishra ji to welcome the another speaker of the session, Honorable Mr. Justice Sanjay Kumar Mishra, Chief Justice of the Jharkhand High Court, by presenting memento and the bouquet. Welcome, sir. Also, we have Honorable Mr. Peter D. Maynard, the President of the Commonwealth Lawyer Association. Is there no? Yes, yes. May I request Honorable Shri Prashant Singh sir to present the memento and bouquet and welcome the President of the Commonwealth Lawyer Association. Thank you very much. And now the subject on which we are going to discuss in this particular session on the access to the justice and the legal aid in the developing nations. I will hand over the mic to the Honorable Chairman of the function to have a deliberation and a discussion on a very important subject. It's over to Honorable Chairman, sir. Thank you very much.
My distinguished colleagues on the panel, my esteemed colleagues, Honorable Justice Aniruddha Bose and Honorable Justice Rajesh Bindal, my esteemed colleague from the Nepal High Court, Honorable Justice Sapna Pradhan Malla, Honorable Justice Sanjay Kumar Mishra, Chief Justice of Jharkhand High Court, Shri Peter Maynard, the President of Commonwealth Lawyers Association, Chief Justice Prasanna Varade, Chief Justice Aprish Singh, all the other honorable delegates present, and dear students. Today we are here to deliberate on an important topic, access to justice and legal aid in developing nations. I don't propose to give a speech. As we have discussed, all of us will express their views in 5 to 6 minutes each, and thereafter we'll have an open discussion so that the views of all the delegates and our views can be exchanged so as to find out a solution to an important aspect with regard to access to justice and legal aid in developing nations. As all of us know that the developing nations, as are known as the global south, have a vast divide between the population, on an economic plane, whereas the wealth is concentrated in few hands, and the vast majority lives in a abject poverty. Insofar as India is concerned, in the preamble itself, we have assured to all our citizens justice, economic, social, and political. Insofar as the justice is concerned, the person who has means has no difficulty. He can easily have an access to justice. He can afford the fees of the best of the lawyers, and the justice is easily accessible to him. But what happens to the vast majority living below the poverty line? The problem arises of providing justice to them. I am reminded of what the Honorable President of India, Draupadi Murmu, spoke on the last 26 January 1950 at the Constitution Day function in the Supreme Court. She said that we talk of justice to all, but she recollected of an incident when she was the governor of Jharkhand. She said that she found that thousands of people from the Adivasi poor tribal area were languishing in jails on petty offences. And she asked a question as to construction of new jails is what the development of the nation is for. She was saying that the women are, the wives of the persons, Adivasi persons languishing in jails, find it even difficult to engage a lawyer, because if she has to engage a lawyer for getting a husband bailed out, she may have to sell whatever small jewelry that she has. And therefore, we must address this issue. No doubt that in India, we in the directive principles, under Article 39A, we have recognized the right to legal aid. The National Legal Services Authorities Act has also been enacted so as to provide for legal aid. My learned colleagues would be speaking on detail on that subject, and therefore I won't dwell much on that. But in India, we have a legal services authority working from the national level up to taluka level. The right of access to justice, in my view, would not only mean providing a legal aid of a lawyer who doesn't have any standing at a bar. The right to legal aid would also include a right to effective legal aid. We came across one of the matters day before yesterday, wherein a convict for 302 was hanged to death by the trial court. After the evidence was closed, the arguments were closed on the very same day. On the very same day, the judge fixed the matter for judgment after 2 days. And on that day, even when the judgment was not ready, the lawyers were called upon to address on the sentence, and the convict was directed to be hanged. So basic rule that unless a judgment is available, the accused is made aware of what is found against him. He has to be given an opportunity to address on the sentence, but these basic principles were not followed, and therefore we had no other alternative but to set aside the order of conviction and remand the matter so as that the accused gets a right of fair trial. The Supreme Court in the case of Anokilal, in a similar circumstances, had also remanded the matter and directed that the accused should be represented by a lawyer who shall have a standing of not less than 10 years. The right to access to justice has been secondly described by one of the finest judges of the country, Justice Bhagwati, in the case of Husainara Khatun versus the Home Secretary, and I will only quote him. The right to free legal services is therefore clearly an essential ingredient of a reasonable, fair and just procedure for a person accused of an offence, and it must be held implicit in the guarantee of Article 21. This is a constitutional right of every accused person who is unable to engage a lawyer and secure legal services on account of reasons such as poverty, indigence, or incommunicable situation. And the state is under a mandate to provide a lawyer to an accused person if the circumstances of the case and the needs of the justice so require, provided, of course, the accused person does not object to the provision of such a lawyer. As we have a right of equality under Article 14, the Nepalese constitution, from which my learned colleague comes from, there is an Article 18 which also shares the same values. There is also a Legal Services Authorities Act of 1987 in Nepal, which follows our pattern of legal services. Many of the law students are present here, and I must comment that in many of the national law universities and the law colleges, the students are actively taking part in holding the legal aid clinics so that the citizens are aware about the rights of legal aid available to them. The Bar Council of India, as well as the various bar councils of the state, as well as the bar associations at the local level, also play a pivotal role in providing legal aid and legal assistance to the needy persons. With an advent of technology, we must also find out as to whether the technology can be used for providing easier access to the justice to the litigants. We are now having e-courts, green courts. During pandemic, the Supreme Court of India started functioning within 24 hours of the national lockdown being declared. I was fortunate enough to be part of the first bench along with Justice Ramna, who was a senior most Supreme Court judge at that time, and Honorable Justice Sanjay Kishan Kaul, who is chairing the another session at the same time. And therefore, with the advent of technology, the Supreme Court and as well as the various high courts, even during the period of lockdown, could cater the need to the needs of lakhs of citizens. The people residing in the remotest part of the country were able to knock the doors of the Supreme Court by virtual mode. Therefore, I must congratulate the Bar Council of India for organizing this conference on an international level and also choosing a subject which will go on a long way in finding solutions to the problems faced by millions of citizens residing in development countries of having not adequate access to justice. With this, I open the session and request my learned brother, Justice Aniruddha Bose, to give his views.
Thank you, Honorable Justice Gawai, brother. This is the one. And distinguished guests, dignitaries, and students. As my learned brother, Justice Gawai said, our task today is mainly to initiate some kind of thinking discussion on this subject. Large part of discussion on litigation in India has revolved around how to reduce the pendency. But in my personal view, and I'm sure many of you share this, more than docket explosion, docket exclusion is a major problem of our justice delivery system in India today. We have adopted a unique approach in India in resolving disputes. We have not outpriced our system where a larger number of aggrieved citizens cannot come and ask for justice. There's an Irish or English judge who said that, yes, in our country, everyone has access to justice, like Ritz Hotel, which was a very expensive hotel there. So we are not a country like that. We have adopted, essentially our framework has three features. First is special legislations targeting deprived and vulnerable sections of the society. In this category would fall all the anti-child labor legislations, prevention of sexual harassment of women in workplace, anti-dowry legislation, legislation on right to information, and also legislation making legal aid a statutory right. Secondly, we have a vast network of law courts. We have approximately 3,500 district court complexes in 762 districts. It would be around that because districts are kind of increasing every day. Supervised by 25 high courts, as also special tribunals dealing with consumer complaints, housing related disputes, Human Rights Commission, and in many cases, many states, medical negligence. Those complaints are also addressed to special commissions. If you look at the pending figure, which is a very daunting, it's about 50 million, which is 5 crore. But I was rummaging through the figures that in 2022 itself, our courts have disposed of around 2.5 crore, 25.2 million cases. So this 5 crore is a dynamic, it's not a static 5 crore. The moment you file a case, it becomes a pending case. So today you file a case, in the board it will show as pending. So, okay, it's for us in the legal community, both sides of bench and also in the academia, It's a depressive figure of this 50 million, but it's actually not that bad. If you look at the manner in which the figure is arrived at, and also if you look at the disposal rates. We have also introduced a system outside the traditional judicial mechanism, like Lok Adalat, mediation, etc. The Lok Adalat the first Lok Adalat, National Lok Adalat in 2023, we had disposed of around 9.75 million cases pre-litigation. The third and the other unique technology we have developed is in the shape of what we call public interest litigation. It's a modified form of, I wouldn't say modified, it's an advanced form of class action litigation, where a litigant would only have to show interest in a subject and take up the cause of large number of docket excluded people. So now, how do we balance these two apparently contradictory approach of inviting more people to come to the law courts and also try to limit the number of litigations? I think that would be for the House to discuss. I'd stop at that. Thank you.
Thank you, Justice Lewis, for being brief and educated. May I now call upon Honorable Justice Bindal to speak. Good. Yeah, very well.
Honorable Mr. Justice B.R. Gawai and Honorable Mr. Justice Anirudh Bose, Judges, Supreme Court of India. We have with us Honorable Mr. Justice Sapna Pradhan Malla, Judge, Supreme Court of Nepal. We welcome her. Brother Sanjay Mishra, Chief Justice, Jharkhand High Court. Mr. Peter D. Menard, President of Commonwealth Lawyers Association, is there. We have Attorney General Venkataramani also with us, my other brother judges from high courts, advocates, ladies and gentlemen, and especially the students. First of all, I am thankful to the Bar Council for giving me the opportunity to be with you this morning, and also for holding such a conference on important issues. In the morning you have all heard our Prime Minister and Honorable the CJE also dealing with that. When I was reading with the subject, the introduction of that, what I could find out was that there are 4 issues they have mentioned in that. Because session is important, access to justice and legal aid in the developing nations. First I noticed was the challenges. Because if we want to overcome anything, achieve a target, then there are challenges everywhere. So this is one which I could notice. Importance of legal aid is the second part. There is no doubt about it, because in all developing nations, like in India also, we have about 50% population living in the rural area only. Or there are large percentage below poverty line. And third is the empowering communities, different communities who are in litigation but can't afford, as an example has been given. And most important is the promoting rule of law. That is the ultimate object basically. But I think the subject is so vast that maybe one session on this may not be sufficient. It requires a full independent conference on this only, if we really want to maintain rule of law. But I was reading something. If you take the India, this is not something new which came in after independence only. I read one book, I was surprised to see that this was in the Mughal era also. They used to call the lawyers who were appointed at the expense of the state Vakile Sarkar or Vakile Shrai. This was there in the Mughal era also. Paid by the state only, they say 1 rupee per day or something, which I read. I never read it earlier, I must confess it. The first legal aid society was constituted, registered in Bombay. It was Bombay Legal Aid Society, which was registered in 1928 before independence. Thereafter, you all know there are reports of Justice Krishna here and then Justice Bhagwati on this prior to the amendment of the Constitution in 76, and then the judgment, brother has already read it, but one part in that judgment is important, which says that this is a right equivalent to the right guaranteed under Article 21. So it has taken right to life into it. But if you see the challenges, I think the most important challenge in this is the infrastructure. If we want to really want to provide the legal aid to the needy persons, then funding is there. Topography is another problem because you have to reach to the people. Digital divide. We are in technology era, but there is a lot of digital divide in the country, especially the developing nations. So you can't really use the digital mode for that. But important again is the empowerment. And unless we empower the people, people know about all these facilities, the legal aid or the other benefits under this act being provided, they can't make use of it. So that's why I think this is the most important part, and all the judges especially and the lawyers must have noticed that in 21-22, when Justice Lalit was the chairman of the NALSA, outreach program initiated, launched. And I think in that program we could see the result because a lot of effort was made at that time and they could reach to every village in the country, I think thrice, all teamwork basically. So this is how the achievement can be there if you reach to the people. The object can be achieved. If you see in India, what I could find out from the figures was that under the various schemes, 30% are the women who are availing the 30% are the lower income group, and 17% are our low-trodden society. And totally the 83% are these three categories only. And then you go to the litigation. We have about 2/3 litigation in criminal side only. And most of these people avail of the facilities in criminal side. And as has been shared, our Honorable President had shared in the Constitution Day, that these are the poor people who are living, who are staying in jails basically. And the reason is either they are not getting proper legal aid or they don't even know about it. And second is maybe the quality of legal aid provided to them is not good. As Justice Lalit used to say that legal aid to poor should not mean poor legal aid. Because this is what is happening. There is a lot of feedback on that. There are research carried out that the quality is somewhere compromised. I think that is the most important part. We need to see that. And what we see in jail, because we also had been visiting various jails during our surveys in high courts and all that. So a lot of poor people are in jail only for the reason that they are not produced in court. Petty offenses are there. Or they are released on bail, order is there by the court, but they have not been able to furnish the bonds. Maybe some conditions are stringent and all that. So this is the area where the legal aid clinics in the jails may have to be made robust so that they take care of all these things. As has been shared, we have 4 levels of these legal services. NALSA is there, state is district, and then taluka level. And this is the important information, I think. We have about 50,000 panel lawyers in the country, and 75% of them are women. In the morning we talked about 33% only, but 75% of them are women. We have about 11,000 legal aid clinics, legal services clinics in the country otherwise, but in jail also we have 1,200. So this is how legal aid is being provided. But still we need to do more. We have about 22,000 legal literacy clubs in the schools and colleges. It's not a small figure. Mobile vans are there, 70. And India, we all know, now on the top in the population also. We have surpassed China, maybe by a few lakhs now, but going further. And is the fastest, I think, growing economy. in the morning also it has been shared. And I can see, and I have seen the figures also and visited some of the countries, see the legal aid system there. I think this is one of the best legal aid system in the world, which is funded by the government. A lot of things are being done. I think we need to map the entire country, and any country can do it. I have some figures, just interesting figures. We have about 640,000 villages in the country. Out of that, about 230,000 villages are very small, where population is less than 500. So very small villages. Balance would be 410,000. There are 463,000 common service centers which provide a lot of information and services to the people. Practically in all village you have common service center. We have about 4 to 5 lakhs law students in the country. And with that, about 23 lakhs, as Mr. Mishra shared in the morning, advocates. If we collect all of them and have a collective effort, I think there can't be any place in the country which can't be touched or informed or educated about the legal aid activities. And if we do that, I think we can achieve all the objectives in this. It's only that we should not work in silos. We have to work together, collectively. One idea was floated earlier in the conference, that how to reach them, and that was that there can be a message on the postcard or Indian letter. This is something for the social welfare only. But I could see the figure interesting, though a lot of postage has been taken by the courier companies. There is annual traffic of about 70 crores postcards and the inland letters in the country. So see, and postcard and inland is being used only by the poor people now, we can say. So this is how the message can reach. About 34 crores newspapers are registered for postage. There also they have the cover. Why not we have on that also? One we had started in Punjab was we could use this on the court notices also. When the court notice goes in any case, you mention on that. We should mention about the e-court project also on that how to access the information and all that. Some brief idea of that. This is how you can reach. One more thing I was thinking was that there are a lot of newspapers being circulated, English also, local language also, and if you find a lot of blank spaces going in that newspaper, where nothing is printed because sometime in adjustment it is not there. Why not to coordinate them and print these messages at those blank spaces? We are not taking any space from them. So no commercial loss to any newspaper. It's just a matter of coordination. Especially the local languages, it will reach few people. Gradually it will reach to more. And similarly, why can't the TV, local channels? A lot of reach is there of the TV also. For improvement, I think now recently the Legal Aid Defense Council scheme has been launched and the success rate is good, the quality has improved. But still I think we need to do more in that area. And equally important is the quality of the prosecution also. It's not that we concentrate on one, though it's not part of the legal aid, but the government has to think about the prosecution part also, because that is equally important. Technology is there for monitoring all this. Yes, we can use that for monitoring. And we are the largest country, and anything which is done in this country means all tested, and any country can simply adopt that procedure to apply in any of the country, because all countries are then comparatively smaller. As we have seen the digital payment part, I think we are topping in the world. Nowhere any country is there, and everybody is seeking to adopt that technology. With all these words, I am thankful to the Bar Council, and I will just request the advocates and the law students are there, because it is your role in this basically to provide it and also to provide quality legal aid. Thank you. Jai Hind.
Thank you, Justice Bindal. May I now request our sister from Nepal, Honorable Justice Sapna Pradhan, to express her views briefly.
Thank you, Chair, panelist judges, other speakers, eminent lawyers, public prosecutors, professors. I'm quite inspired by a book from Amartya Sen, of his idea of justice, which talks about capability approach. And that reminds me that justice is all about capabilities and opportunities. How we'll build the capability of individuals or marginalized groups. So for me, legal aid is a means for justice. Legal aid is critical for enjoying all other rights, and it is also about heart of equality, prohibiting discrimination. But until now, even if we look at international human rights instruments, yes, we do have a provision for legal representation on UDHR, ICCPR, ICSCR, but we have a specific general recommendation number 33 under CEDAW, but adoption of UN principle and guideline in 2012 was a groundbreaking steps towards strengthening justice everywhere. So the guideline has created obligation among the member state, which includes accessible, effective, sustainable, and credible legal aid system. Again, I want to go to Nepal, where in 1958, when many of us were not even born, Nepal introduced court-paid lawyer. So we have a court staff who is hired as a lawyer, and that system is still a most functioning system in Nepal, where each court has their own lawyer and who provides legal aid. But the limitation is this legal aid is provided only when cases comes to the court, not on a trial, or when they are in detention. And in 2007, legal aid to indigent people were recognized as a fundamental rights. And in 1997, as just Gawai said, that we had adopted a law, and that also came as a private member bill, not as a through the parliamentary process, but through private member bill. So we have again, like listening to previous speakers, Justice Bose and Justice Gawai, we also heard like it's legal aid is also an awareness, and the Supreme Court of Nepal has been publishing different rights awareness booklets, which not only talks about right, but where to claim the right, how can they claim the right. And we even have a right of people with disability in a Braille language. At the same time, there is a legal aid system, legal aid service provided by BAR, other NGOs, INGOs, as well as UN system is also providing. And then we have now a legal aid, comprehensive legal aid policy, which has tried to decentralize legal aid services up to the local level. We do not have a Lok Adalat like India, but I'm quite impressed to hear what Justice Aniruddha Bose has shared, what achievement you have made through the Lok Adalat, but we are hoping similar success we can get through this local community. This is mostly focused on community justice, and also this is focusing on mediation. Nepal is recently federalized, but we have a unitary integrated judicial system. So in this ideology, we have this judicial committee, which is an elected body, but we are expecting them to give the justice, community justice. So we have yet to see the result it can bring. And I was quite impressed with Justice Gawai, and I want to salute you for your stand for the fair. You stand for the fair trial, and you have proved that legal aid is not only for the victim, it is also for the accused. No matter who is the offender, you cannot compromise with right to fair trial. And I think this is one debate which we still have, and time to time we can see the tension. I was following when the case was in your bench, and I again want to salute you for this. So there are different kind of challenges which we are going through, and as Justice Bindal, Justice Bose has already said, we have a shared challenge. We have a shared common nature of challenges, and especially in this region where poverty is deep-rooted, disparity between haves and have-not is very wide, and then we also have a Sustainable Development Goal 16, which where we have, our government has made commitment, and we have only 7 years left to achieve the goal to ensure justice for all. So we have a long way, and then law matters, but how to put law into place with strategy, with resources, with action is a challenge. And when we talk about legal aid, legal aid is not only critical when your liberties are put at risk. What we have realized in Nepal during earthquake, we had a massive earthquake in 2012, then during COVID, even for transitional justice, because we lived in conflict for years, and even in gender justice, in accessing justice for sexual minority, legal aid has helped, and public interest litigation has also helped. I still remember during COVID, earthquake, many people, they lost their ID, their property ownership paper. Legal aid was quite instrumental at that time. And during COVID, it was not, like people were dying, but there used to be birth with its death. And that time, Nepal court also developed COVID jurisprudence, unhindered access to reproductive services even during pandemics. So as what was happening in India, many people were released from prison because there was no vaccine, and to protect the life, we also released many individuals, even children from child reform home, and now again we are confronting with different issues, and the major issue at the moment is resources. And I completely agree with my brother judges that we need to audit the budget. How much budget is allocated? Because investment in legal aid is investment for justice and equality. We are still confronting with quality justice, and for that, what we have introduced in Nepal recently is a concept of pro bono, and we are trying to institutionalize it with the adoption of a guideline, but we still need to make it functional, because what we are hoping through the pro bono from senior lawyers or big law firms, maybe we can make a quality legal aid. And I also want to remind to my sister and brother lawyers here that we also have a responsibility, basic principle on the role of lawyers 1990 provides responsibility on legal professionals to ensuring that everyone has access to counsel, regardless of means or background, to protect the right to equality before the law. And also other mechanism which we have created, because sometimes the legal service seeker, they want to be represented by themselves. So we have also drafted and adopted a guideline by the court that people can represent by themselves if they want to do so. And the challenge which we are going through right now is whether legal aid is an absolute right, because in our parts of the world, it may be subject to legitimate restriction with means test and merit test. In criminal cases, the interest of justice are critical determinant for granting legal aid. However, careful examination of means test is important, especially looking at the high legal fees, court fees, and other incidental expenditure required in accessing justice and individuals' capacity to do so. In Nepal, now we have, after having this comprehensive legal aid policy, we are drafting a new bill, and what we are confronting with a mechanism. Who should lead, whether this institution, the body to monitor, to implement legal aid should be an independent body, or should it be under the government or judiciary's supervision? So we don't know what mechanism works, and I'm really looking forward, and I was just talking to my brother judges, and they were sharing how the Supreme Court judges or other judges are chairing the commission, different bodies at a different level. So it will be interesting to learn more from the discussion. And then again, I think what is also important is a robust national data collection system, which was talked about my brother judge, and therefore, at last, I would like to say, justice system has to be economically accessible. One cannot let them suffer from injustice or arbitrary power just because legal counsel is unaffordable or inaccessible. Democracy and development requires true rule of law, which is impossible if justice is not accessible to all because of socioeconomic polarization. And I would like to thank you, Bar Council of India, for creating this forum, where we all have been talking that legal aid is fundamental necessity of human existence in accessing justice system, and conversation has begun, and we need to continue unless we have a quality and effective and functional legal aid system in place. Thank you.
Thank you, Honorable Justice Sapna Pradhan, for sharing your experiences from our neighbor, Nepal. I must also congratulate for the proactive role played by the Supreme Court of Nepal in the COVID times, so as to provide succor to the needy. Now, may I call upon Justice Sanjay Kumar Mishra, the Chief Justice of the Jharkhand High Court, to kindly share his views.
Good afternoon, and as it say in Jharkhand, Johar. Honorable Mr. Justice B.R. Gawai, Chairperson of the session, Honorable Mr. Justice Aniruddha Bose, Co-Chair, and also formerly the Chief Justice of Jharkhand High Court, Honorable Mr. Justice Rajesh Bindal, Co-Chair, Honorable Mrs. Sapna Pradhan Malla, Judge, Supreme Court of Nepal, Honorable Mr. Peter D. Maynard, President of the Commonwealth Lawyers Association, Honorable Mr. Justice Sagdar, Judge, Delhi High Court, Chief Justice Barale and Singh, who are also present, Learned Attorney General Mr. Venkatramani, delegates from different states of the nation, and also delegates from other countries, neighboring countries and other countries, and law students, ladies and gentlemen. I have been working in 3 high courts by now, my lord, and I have gathered many practical experiences. So I'll not speak on the philosophy behind legal aid or the legal aid movement. I'll just share one case study. When I joined in Uttarakhand, being the senior-most judge, I was asked also to act as the executive chairman of the Uttarakhand Legal Services Authority. And in such capacity, I visited few jails. And it dawned upon me, actually in Uttarakhand there are very few jails. Because of the topography, it is difficult to have too many jails in Uttarakhand. I could see that there are many cases where because of lack of legal aid, a person who is convicted of a very serious offense like murder might not have filed appeal to the High Court of Uttarakhand. So as the chairman, executive chairman of the SALSA, I interacted with all the chairmen of the District Legal Services Authority and requested all of them to find out time on a day off, which is not their judicial working day, and visit the jail and find out if there is any persons who are lodged in the jails who have missed the opportunity of filing an appeal against the conviction. And all on a sudden, I was also looking at, after joining of Justice Bipin Sanghi as the Chief Justice, I was also asked to work 1.5 day on criminal side and in the division bench hearing criminal appeals. So I saw that there is spurt in filing of jail criminal appeals. The learned advocates, delegates must be aware of what a jail criminal appeal is. Maybe the law student may not be aware what jail criminal appeal is. Jail criminal, as you know, the state is under an obligation to provide legal aid, and if a person is convicted and is in custody, he doesn't have the requisite means to prefer an appeal. It is the duty of the state to provide him the legal aid or legal services so that he can prefer an appeal. And an appeal came before us with an 18 years delay. A person has been convicted, and 18 years thereafter the jail criminal appeal was filed. On the first day itself, I allowed the application for consideration of delay, saying that it is not the fault of the prisoner, it is the fault of the state who did not provide him the adequate legal aid to prefer an appeal. And first we condoned the delay, and then we appointed the amicus, a very smart young girl advocate or woman advocate who was appearing frequently in pro bono matters. So I asked her, can you take up this responsibility? And the next day she filed an application for bail. And fortunately, myself, or rather my partner and myself, had read the file the night before. And to our utter surprise, there was not an iota of evidence on record to convict the person. And he was suffering in prison for 18 years. When the advocate amicus started arguing for the bail, both of us almost simultaneously said, why asking for bail? Just argue on merit, we will allow the appeal. But she was not very confident, perhaps because she was young, and she asked that a date may be given. I'll examine the record again, because I was only asking for bail because there is 18 years already in custody. We granted one adjournment. On the next adjourned day, we allowed the appeal on the dais itself. So this is a case study which I say. This needs a bit of application on the part of the learned judges, the learned advocates, or even the students who are member of the legal aid society in their respective colleges. A bit of application may go a lot of way to ensure proper legal aid, and I implore upon all of you, as a upholder of the Constitution or as legal professional, to just have a bit of patience and a lot of applications. At the end, I like to quote Rashtrakavi Ramdhari Singh Dinkar, whose couplet appears to be very appropriate for this solemn duty that we are required to do of providing legal aid. मेरा हिंदी थोड़ा अच्छा नहीं है, फिर भी कोशिश करता हूँ. शांति नहीं तब तक, शांति नहीं तब तक, जब तक सुख भाग न नर का श्रम हो, सुख भाग न नर का श्रम हो, नहीं किसी को बहुत हो, नहीं किसी को कम हो. Thank you. Vande Mataram.
Thank you, Chief Justice Mishra. Now may I call upon the last speaker, Mr. Peter Maynard, to briefly address us. We are running short of time.
आमंत्रण के लिए धन्यवाद। Distinguished judges, platform guests, distinguished ladies and gentlemen, I see distinguished Attorney General present as well. I had the pleasure of meeting with the Attorney General during my last visit in March, and I'm looking forward to further interaction. It is a great pleasure for me to be here. I bring warm greetings from the Commonwealth Lawyers Association, which consists of 56 jurisdictions. And indeed, our core mission is access to justice. And perhaps I can add one advantage or disadvantage of being the last speaker is that everything has already been said. And so I could very well say, good afternoon, thank you very much. Nice to meet you. And I won't keep you, but I'd like to also extend warm congratulations to this beautiful and great country, not only for the G20 meeting and landing on the moon, but also for the reservation regarding women, because that eventually will lead to better access to justice. I want to mention some specific areas. Many have been touched on already. Perhaps I can add an international outlook, because I'm learning a lot about India this afternoon myself. Legal aid programs have been mentioned, legal aid clinics, in law schools. I know that students are present, and I also engage with students a lot. Community-based legal services, mobile and virtual legal clinics. E-courts were mentioned this morning during our very informative keynote addresses. Public awareness campaigns. Simplify legal procedures. They're often very complicated. ADRs, training and capacity building, providing public defenders, public advice, pro bono, legal aid services, and closing the digital divide, legal technology, community legal education, legal empowerment initiatives that help marginalized groups such as women, minorities, indigenous communities. The Prime Minister referred to litigants choosing their advantage, their own language, for example. Legal aid funding resources are always an issue. Reduce court fees, improve court efficiency, access to interpreters, law reform, continually reviewing and updating the laws, monitoring and evaluation, collaboration among government institutions, civil society, legal professionals, and international agencies, and political will to provide the highest levels of priority to this fundamental human right. Access to justice, has been said, lie at the very heart of a just and equitable society. This is not just a matter, these topics are not just matters of legal technicalities, but they are of matters of human rights, social progress, the very essence of our shared humanity. As we must recognize, and make three points. We must recognize that access to justice is not a luxury, but a necessity. As Mahatma Gandhi said, the true measure of any society can be found in how it treats its most vulnerable members. Legal aid is a bridge that connects vulnerability to empowerment. Access to justice is a human right, as reflected in the core mission, and also in Sustainable Development Goal 16, as has been mentioned, the Universal Declaration of Human Rights, the International Covenants on Human Rights. Empowerment we must, secondly, we must support and strengthen legal aid programs. Governments must provide adequate funding, but also lawyers must do more pro bono. Empowerment, education, and informed action are critical. We must empower individuals with legal knowledge and awareness of their rights and obligations. It was my honor to have been the draftsman of a declaration of the International Bar Association back in 2008 on the pro bono, which was adopted unanimously in Buenos Aires. And that declaration recognizes that there must be a broad legal aid educational program and to establish a strong pro bono culture of pro bono service. It also deplored the fact that access to the courts and effective representation and advice are not afforded to all those who need them, especially the poor, underprivileged, and marginalized. We must advocate that barriers to justice, wherever they exist, should be broken and dismantled as a matter of urgency. It also recalled that access to justice for all individuals is a human right, and the governments have the primary responsibility to realize and protect that human right through measures such as state-funded legal aid. Also, I believe that a determined effort is needed to advance access to justice through pro bono work and to strengthen the commitment to public service in the legal profession. Within the CLA, we continue to develop strong, mutually beneficial training programs and events. We have the opportunity at this conference to discuss specific measures to improve access to justice and legal aid. And I am pleased that within the CLA that we have a number of many lawyers of India, as well as I expect and hope that the Bar Council will come on as a member of the Commonwealth Lawyers Association, and so we may continue along a very powerful and meaningful journey. In conclusion, the quest for justice, access to justice, is a noble pursuit for fairness, equality, and human dignity. Each one of us, in our respective roles and capacities, can continue that quest and contribute to it. Let us be the change, and let us work tirelessly so that justice is not a distant dream, but a living reality for all. I wanted to leave time for questions, and so आप सबके मुझे दानियान से सुने के लिए धन्यवाद.
Thank you, Mr. Maina. Now, invite the questions from the audience. Yes.
Sir, I also have a question.
Hello, sir. My name is Ananya Tyagi. I'm an advocate. My question pertains to non-inclusion of transgender under the Section 12 of the National Legal Services Authority Act. Because recently there have been a lot of issues in their mainstreaming into the public eye with regards to free legal aid. And what are the global best practices that India can adopt for the inclusion of same? Thank you.
I think that's an issue which is in the domain of the legislature. And some litigation with regard to that is pending before the Supreme Court. So it may not be appropriate for at least us to answer that issue.
Okay, thank you, sir.
Yes, Mr. Gaddam.
Honorable judges.
My lord, I have an issue in view of the discussion about access to the justice system. I am Sanjeev Kadam, President of Advocate Association of Western India, Mumbai High Court. My lord, in order to have easy access, it has to be easy access for the common litigants. Would the honorable judges of the Supreme Court or the Supreme Court or the government would be thinking about creating the benches of the honorable Supreme Court, at least 4 or 5 benches in the nation, so as to make the access easy to the common litigants? Thank you.
That's a suggestion. We'll put it to the Chief Justice.
But I think I may just answer this. This is not required now. You can sit at your home and file the case and argue from there only. Practically, the Supreme Court is at your residence only.
Many litigants, my lord, Justice Bindal, many litigants think that for e-court, the known places are working better. Many litigants think this. I am being very honest.
That
Yes,
is
that girl from the second last line. Please tell your name.
Good afternoon, respected dignitaries. My name is Aishwarya Ambar and I am from Christ deemed to be University. So my question is related to, since Sir Peter D. Mayer talked about basically empowerment and communities, my question is, how can the legal systems of developing nations navigate the intricate balance between the culture and customary practices in the indigenous communities? Because the traditional norms may contradict with the internationally recognized human rights standard.
Yes, Mr. Maynard.
That's an excellent question, how to navigate through the cultural norms. In many societies, they are quite favorable, and others they aren't. I think the change comes through determined efforts by each of us. This is not a matter which is determined only by one person or the other, or by the government alone, or by one set of institutions. But I think it's something that falls upon each of us to make the change. And it can indeed be very difficult in circumstances. The good news is that in some communities there are changes across the 56 nations. In others, there are some very intractable circumstances which we need to continue to work on.
Thank you, sir.
Sir, I'm Mahadevan, President of Nilgiri Bar Association from Ooty, sir. Here we have been talking about all the systems and all the things that whatever laws are enacted and what are the things that should be gone to the general public. Here, as Justice told, that it was 18 years that an appeal should come here. But as we all know that today there are visiting advocates even to jails and everywhere. But if that could have been done by the advocate or the legal, because he is also from legal thing only, that he has been sent there to the jails. He should instruct all the, inform all the accused that they have these modalities, all these things are there. Here what I say is, since there is no proper guidance that has been going to the common man or to the downtrodden people, they do not know as to such a system is available in India. just to develop that one and to see that each and everyone know that they have such a system that has been adopted. For that, what are we going to do? That is the main thing that should be addressed. That is where we are lacking very much, and that is why all these things are delayed. So what are we going to do that?
This is already addressed by Justice Bindal. He has given suggestion that it should be published on postcards and inland letters, and also the newspapers should be requested to, if there is an unprintable space, they can be requested. And even, so these are the suggestions which are given. I think at the end of the session, the Bar Council will conclude and summarize this and will forward it to the authorities concerned.
Thank you, sir. Thank you very much.
Yes, Mr. Howard.
Sir, I'm from Pune, former chairman Bar Council of Maharashtra and Goa. Sir, I had a query or rather suggestion to Bar Council of India as well as Bar Council of Maharashtra and Goa and Lordships. Sir, this entire discussion, and I'm in profession for last 47 years and in council also. Sir, this will be fruitful only when, according to me, when senior lawyers, front rows, they shall be compelled every year to act in major cases or a number of cases, particular number of cases pro bono. This can be a scheme. This can be a scheme envisaged by the Bar Council of Maharashtra and State Bar Councils and Bar Council of India, and some judgment from the Supreme Court or by the High Court under Article 21, so that this entire scheme can be made and really poor and needy will be benefited, as Justice Uday Lalit sir has said. Thank you, sir.
Well, that is a good suggestion. In the Supreme Court, we have noticed that there is a project by Delhi University, Delhi National Law University, project Article 39A, and we see that many of the senior advocates are appearing pro bono, and they are assisting the court very valuably in the death matters. As a matter of fact, the matter to which I referred in my opening remarks, one of our very senior counsels had appeared for that accused, and had such a valuable assistance been available to him at the stage of trial, the matter might not have come here. Yes, madam.
Sir, myself is Advocate Shabnam Kazi. I am a coordinator Bar Council Maharashtra Goa, as well as I represent DALSA, that is Mumbai Suburban. Along with my private practice, I do pro bono services. My question is, we are in a gender bias, we do not have gender bias laws. Then why till date there is no change to the aspect or the section of law wherein women are allowed legal aid irrespective of their financial strengths? What, as lawyers, we observe that this provision of law is misused by affluent ladies when it comes to taking services, while actually who deserves legal aid does not get legal aid. Can we do some recommendations for making it in such a manner that only the one who deserves it should get it?
It doesn't get exhausted. That legal aid
Lordship, considering the bottlenecks in our justice delivery system.
Please tell your name.
Lordship, I am Sharik Ahmed, the practicing advocate in Supreme Court. My Lord Justice Gawai, Lord, considering the bottlenecks in our justice delivery system and what Justice Bindal recently said, by quoting Justice Lalit, that legal aid for poor should not be poor legal aid. Lordship, how far the Strickland test as laid down by US Supreme Court is feasible in a country like India?
We didn't get it. How?
So how far the Strickland test as laid down by United States Supreme Court is feasible in a country like India?
Sorry, I'm not aware about that. Is anybody on the dais aware about that?
Associate Judge of the Supreme Court availing...
Lordship, about the poor legal defense. It's about the poor legal defense, and it was applied by the Honorable Supreme Court in Ashok Dev Burma's case in 2014.
You see, for that only legal, this defense counsel scheme has been made. With that, quality has improved now, because there they have the retired public prosecutors or the retired judicial officers also who are conducting the cases. So gradually it is improving now.
Sir,
the learned attorney also.
Sir, may I aid in this case?
Yes, yes. We have the privilege.
Yes.
A few words to be shared with the students here. My first brush with justice doing was a legal aid matter. And if you are in the legal profession, the alphabet you should be learning is try to understand the pains and anguish of all those deprived sections of the community. The first lesson you must learn as a student of law. The whole pursuit of justice is all about knowing and understanding the anguish and passions of people who are in deprived conditions. Long ago in 1968, Anthony Lewis wrote a book called The Gideon's Trumpet, which set the pace for legal aid in the US legal system. Now, we have come far, far away. But what anguishes me is this. We still have a large sections of community. We use the word access to justice in a very confined, in a narrow way. As long as we create systems of justice which will deprive people from accessing justice, we are going to continue to chase an illusion. We must probably fundamentally alter our ways of doing justice. And different sections of the community have different justice needs. If inequality runs through the social order, our justice needs will be different. But we try to have a one scale good for all and try to provide an access to justice, something we need to seriously look at. The Supreme Court of India, of course, has done tremendously well in trying to unravel these dimensions over a period of time. What I need to talk here is not to address those well-placed, well-accomplished legal professionals, but to the students of law here. So when you go back with the passion that you have, all of you, and every one of you are legal services authority unto yourself. Each and every one of you are a legal services authority. And then once you understand that, and it's going to be a role in the legal profession, perhaps we would have gathered a lot of insights. I only want to have this, what I may call a passion for doing justice must come and continue to be a burning flame in you. Please do that. And if you are able to even catch 1/10 of that passion, probably would have done justice to our nation, our country, and probably all the international gatherings here. And please do that. And probably when many of you have graduated, and at some point of time, we will meet again in some other place, you would have shared with me how passion has brought you into the forefront of being vehicles and engineers of doing justice for the common women and men. I would like to only say that and conclude with this.
Yes, the learned Vice Chancellor.
Just one sentence to add to. Thank you, my lord. This is just an exhortation to students, adding to what Venkatramani said. Passion for what you do and compassion for whom you do should be your goal.
Yes, sir, young boy.
Sir.
Yes.
Good afternoon, all of you. Sir, I was reading about the human rights of the prisoners. That subject is widely ignored by all the judges. They shed some light, but not it. I was reading that the most of the under trial prisoners turn out to be innocent some way. Sir, the condition of our jails are not so good that the under trial prisoners can lead a healthy and better life like a normal life they used to live before the conviction is done or during the trial. Sir, I want to shed that all of you will agree that at the international level also there is our motive that no innocent should suffer from law. And sir, legal aid has made all the legal access easy for the people, but sir, the legal aid also have some sort of lack of quality which we can see in the large number of under trial prisoners in the jails leading a unhealthy life, and especially in Tihar jail also, where there is a cell have maximum capacity of 4 persons are filled with 40 persons at a time. So I...
Please give your question, don't give a speech.
So it's not a speech. I want to give a suggestion that at least court should try to do something about the under trial prisoners.
The courts are doing various high courts, Supreme Court. If you have read the newspapers, during COVID period, the Supreme Court had issued so many directions for decongesting the cramped courts, and many under trial prisoners who were, even the convicts who were sentenced for a period of less than 7 years were directed to be released. And the judgment of Hussain Ara Khatun, to which I referred, it pertained to the under trials only. So don't be under an impression that the courts are neglecting the issues of under trial prisoners.
Sir, here.
Sir, young man, I just want to inform you that NALSA and along with Supreme Court has created an under trial review committee which is constantly monitoring the under trials in prisons all over the country, and we have achieved a lot of success there. Please look at the statistics, educate yourself, and then put these questions to the panel.
Yes, Mr. Varun, sir.
This question is about the persons with disability. World Health Organization says that in India, 8% is the population which is having some kind of a disability. Our legislation says 4% reservation. But most of the websites of all courts in India, they are not accessible to the visually impaired person. Most of the court complexes are such that the wheelchair litigant can't have an access to that court complex. So now the time has come that access to justice should also be thought from that angle. What is the view of the panel?
No. If you recollect now, all the new buildings which are constructed are directed to be disability friendly. And in Bombay also there was a public interest litigation, not only court buildings, but all public offices and all, they were provided, there were directions to provide ramps and everything so that the physically differently abled persons can have an access there.
Sir, even today in the Supreme Court, there is only one washroom where a wheelchair person can go. If we go to the Bombay High Court where I am
We are planning to have a new Supreme Court complex which is again planned out in such a way that it will be disability friendly. Yes, one last question because I think we have already...
Sir, I am Manoj Nayak.
Here I am standing for...
Sir, I am Manoj Nayak, representing from the Judgeship of Balasore, State of Odisha. My Lord, so many... Sir, my Lord,
many Mishra is here, the person from Odisha must be permitted to speak.
Sir, one question.
Who is from Odisha?
Sir, my matter is very... My Lord, we have taken very effective resolutions. So far, my district is concerned, my Lord, Balasore Joseph, which was established in the year 1958.
Please put up your question. We are not even here.
Sir, my matter is, sir, for advocates, there is no sitting accommodation. What I mean to submit, there is no bar association. For judicial officers, my Lord, there is no accommodation for the court civil. Minimum amenities like
most of the high courts on the administrative side are taking up those issues.
Sir, how it will be acted upon, Your Honor? How it can be carried out?
Please, sir, आप गलत बोल रहे हैं. अभी we had, as per the statistics that is presented to us by Justice Muralidhar, Dr. Muralidhar, Odisha is the number one state in the entire country where the maximum number of infrastructure development has taken place. You check your facts.
Sir,
thank you very much now.
Hello, sir. I am standing from long time. to the left of you here in the corner.
Yes.
From long time I am standing.
Okay, last question, yes, last question.
Last question, okay.
And can question, no speech.
No speech, sir. Just a doubt. I am from Telangana, Bhadradri Kottagudem district, and previously, under Section 12 of the NALSA Act, the poor people were being issued court fee exemption certificates to file civil suits. Under that. Then later on, it has been changed that the court fee, it will be exempted only till the filing of the suit, but decree will be prepared after paying the court fee. Now, no such certificate is being issued. Previous to that, we used to file pauper OPs under Order 33. But now, neither we are able to file.
How can we answer individual questions here? We are in a...
No, sir. In the state of it's a state issue, sir. No, I don't need any answer. But I want to bring to your notice so that some remedy can be brought in.
Yes.
Whether one clarification I need, whether court fee exemption comes under the legal services or not. If it is yes, then something should be done uniformly throughout the country.
सर हैबिचुअल क्रिमिनल्स जो है सर उसके बारे में मेरा क्वेश्चन है सर ये जो लीगल एड है सर इसका मिसयूज हो रहा है इस विषय पे किसने भी बोला नहीं सर हैबिचुअल क्रिमिनल हमारे यहाँ पर जो इलीगल लिकर बेचते हैं 5-5, 6-6 केसेस है सर उनके ऊपर और बाद में लीगल एड लेके फिर छूट जाते हैं फिर वो वापस से इलीगल एक्टिविटी करते हैं इवन सर जो थेफ्ट है सर मोटरसाइकिल थेफ्ट होती है 5-5, 6-6 केसेस
मैडम ने भी
सर
मैडम ने भी बोला और मिस्टर वायना ने भी बोला कि इट्स अ ह्यूमन राइट merely because of provision is being misused. It can't be said that it should be struck down. So thank you very much. You had a very thank you.
Human rights should be for all, not only for accused.
Thank you.
सबके लिए
Thank you very much, Mr. Please. No, thank you. We are already running out of time. Thank you very much. Thank you very much. We have got a very interesting session. I'm thankful to all of you for participating very effectively. I'm thankful to the panel members. Various good suggestions have come from the discussion. Like the main issue is about the litigants not being aware about their rights. This is Vidal has suggested that the postcards and inland letters and they can be used. So also the local TV channels and the newspapers can be requested. I think I'm grateful to the Bar Council for organizing this conference on this topic. This will give a long way in providing access to the needy persons. Thank you.
Sir, I'd like to thank sir. Thanks, sir.
Thank you.
I'd like to thank the chairman of the session, Honorable Mr. Justice V.R. Gawai, sir, co-chairman of session, Honorable Mr. Justice Anirudh Bose, sir, Judge Supreme Court of India, co-chairman of session, Honorable Mr. Justice Rajesh Bindra, sir, Honorable Mrs. Sapna Pradhan Mala, Judge Supreme Court of Nepal, Honorable Mr. Justice Sanjay Kumar Mishra, sir, Chief Justice, Jharkhand High Court, Honorable Mr. Peter D. Maynard, President Commonwealth Lawyer Association. Of the dais, Honorable Mr. Justice Apresh Kumar Singh, Chief Justice of Tripura, and all honorable judges present in this hall.
Attorney General.
Sir. Honorable Attorney General of India, Sri
Probably
R.
I can make one
Venkatramani, sir.
final announcement, even after the vote of thanks. I have been persuading the government that we are in urgent need of setting up a National Institute for Criminal Justice Administration. And probably that will address many of these questions.
Thank you.
Forgive me, Justice Barave, the Chief Justice of Karnataka High Court. We also acknowledge Anil Singh, the former Solicitor General of India, present in this hall, on all honorable member of State Bar Council, eminent lawyer, professor and student. Thank you all of you for giving their precious time for gracing this occasion. Thank you so much. Sir, Sir, I.
Come, attendees.
Sir.
Attending.
Sir, please.
Sir, please.